So the first topic that we have is the industrial design protection system in the European Union. And what I would like to do, I would give you an overview of how it works here in Europe, and maybe you will find similarities, or maybe you would also find certain differences that you find striking. Right? So I will start. So in the European Union, there are two different options. You can file a design in the EUIPO, which is where we are. We have across 100,000 designs per year that we register, which is quite a lot, of course. The second system that we have in Europe that you can file with WIPO, and that is called international registrations, and with designation the European Union. And they process 14,000 designs per year, more or less. So these are the two options that you want to choose depending on the strategy of each client. Now, there are two things, two design rights in Europe. One is called the registered community design, and the other one is called unregistered community design. So now do you think, why are there two? What is the difference? First, I will tell you what is the same for both, and which is this. Manufacturing a product incorporating a protected design without consent of the proprietor is considered illegal. This is the first bit. This is the same for both. Putting a product on the market incorporating the protected design is also illegal without consent of the proprietor. Offering a product for sale is illegal. Marketing a product is illegal, and also importing and exporting a product is illegal. Now you would think these concepts are the same, more or less, but this is just to cover all the possibilities of infringement that the protection is the most for both cases. So, but if these are the same, what is then the difference? Right. Difference is that unregistered community designs only protect against copying in bad faith. And of course, you don't have a registration certificate because it is not registered. For some designs, this might be enough, because there are some designs that will need a long protection. There's like fashion, for example, or for some designs, it's very easy to show when the design was disclosed to the public. But for other designs, of course, it is not enough. So what is the second option? The other option, of course, is the registered community design. And like it says, protection is also against copying in good faith. And this is, of course, a big difference. And the huge difference, of course, is that you will have a registration certificate for the registered design. And this is a real certificate. You can download it and you can use it if you want to go to the customs, for example, to show that a certain design is your property. So it is clear that a registered community design is the preference if you want the most protection for your design. Right. The next part that I would like to say is the definition of a design. In most countries, this definition will be the same. I will read it to you. A design means the appearance of the whole or a part of a product resulting from the features of, in particular, the lines, the contours, the colors, the shape, the texture, and all the ornamentation. So the important thing here is it is the appearance of a design, so the way it looks. And it might sound simple, but I can assure you that for many applicants, it is not that simple. And then we have a product, of course. So this is the definition of a product. A product is any industrial or handicraft item, including the parts intended to be assembled into a product. So an industrial or handicraft product, including parts. This is important, and I'll show you why. This example, you will see a tomato in a heart shape. This is a real case, a real application, where the applicant intended to file this tomato in the shape because he felt it was different, he felt it was a design. This is a real case. You can look it up in our case law. In the end, it was decided that this tomato does not correspond to the definition of a design. And the arguments were, it is not a product. It is not a living organism. It is a living organism, sorry, I mean. And it is not a result from an industrial or manual process. So this design, in the end, was not registered. The next question that we will treat is that, how do you know then if your design qualifies for registration? Well, first of all, there has to be a product or a part of a product. This is what I said already. Colors, verbal elements, sounds, they do not qualify as an appearance of a product. They are part of a product, but they are not the appearance of a product. Also, living organisms, concepts do not qualify either. And for the same reason, they do not constitute the appearance of a product. And last is a design should respect public policy and certain morality standards. Now, this last topic is of course different in several countries. Also within Europe, this is different. Public morale, of course, depends on the public itself. So each country has different morale and different standards. I will show you some examples. I will give you the time to look at these examples. So what would be interesting for yourself to ask, okay, so where I am are these designs acceptable or are they not acceptable? I think it is fair to say, I'm from Holland, that Dutch people are quite liberal in some cases. In other countries, people are not so liberal. So you will see the hand. Maybe for the people who do not see it, the furniture has the shape of a Nazi swastika. That is on top here. And I don't know if it was intentional, but it does have the shape of the swastika. And the text on the mask, it's, well, I have to translate it for you. That is what it says. So now, the thing is, have we accepted these? Yes or no? I can already tell you that none of these were accepted because they were considered against public morale. And this is why they were not registered. By the way, it was a real filing. So this is also a real example. Right. And then we come to the next thing. What is the route to the registration? What are the characteristics? A registered community design is valid throughout the entire UA. That includes 27 countries. I'm now saying 27 because as of January, the UK, as you may know, will leave the European Union. A good thing is that in the EUIPO, we allow an unlimited number of designs per application. I know that in certain countries, there is a maximum of, for example, WIPO has a maximum of 100 designs per applications. I don't know in other countries what the maximum is, but In the EUIPO, we allow unlimited. And I can tell you each year, the most that we've had was 560. And these were 560 shoe designs. This we get every year, a shoe collection. But the number of designs may be unlimited, but the number of views is limited. There is a maximum of 7 views that will be registered. And there's a minimum of 1 view. I understand that in certain countries also, there is a certain minimum for views that you have to show in order that the design is portrayed in a good way. For the EUIPO, it is possible to file only 1 view. So maybe this is importance is different. The maximum may be 7 protected views, but it is allowed to file more than 7. More than 7 views, they will be stored in the file in case you need it further. The next, the principle of representation. So natural persons who are not, or legal persons also, who are not in the EEA, and the EEA is the European Union Economic Area, need to have a representative that is based in the European Economic Area. The European Economic Area is all member states of the European Union, plus Iceland, Liechtenstein, and Norway. So people who are outside these areas cannot file on their own. Right? The representative, in principle, does not have to file an authorization to act. So unless the office expressly requires it, or where in inter-partes proceeding, the other party requires it. Right? And also, where a representative is appointed, the EUIPO will communicate only with that representative. So all correspondence, this will go to the representative that is on file. Then the next question who is able to represent? Who may represent? Right? Legal practitioners are professionals, and depending on the national law, and this is an important thing to know, it depends on the national law of each country, whether they are fully entitled to act as representative for third parties before national offices. I've given you the articles below. I will not go into those articles, what they say. Professional representatives need to comply with certain conditions. They are included on a specific list that the office holds and maintains. On those lists, there are two types of representatives. The ones who can only represent in design proceedings, in RCD proceedings, and the ones who can also represent in trademarks proceedings, EUTM and RCD proceedings. There are 2 different lists for this, and the requirements are also different for both types. And then we have the next option. Those are employee representatives. And it is very important to know that it have to be employees of legal persons. And they can represent other legal persons, but provided that the 2 legal persons have economic connections with each other. And what are economic connections? For example, the 2 legal persons are members of the same group. So like shares, or they are clearly the same company, or there are certain management control mechanisms. Maybe the board is the same, or the directors are the same. These are economic connections. But the following are not sufficient for economic connections. That is a trademark licensing agreement, a contractual relationship aimed at mutual representation, or legal assistance, or a simple supplier-client relationship. So these are, if the economic connection is one of these, the other party is not allowed to represent third parties who are not within the EEA. Some people make a mistake about this. If there is this mistake, then of course we give the opportunity to correct and to appoint valid representatives. I'm sure you've heard about the Brexit, that the UK will leave the European Union. And of course, this has several consequences for IP rights. It's also for the representatives who are from the UK, from the applicants who are from the UK. The consequences are quite serious maybe, but there are solutions for it. As you may know, there is now a transition period. This will last until the end of this year. And after that, there are certain measures that people have to take. And what is it that we do in this office? We have a whole workforce. We are preparing, of course, because this change is for us, has for us huge consequences. What we will do, for example, is we will invite right holders who are now outside the EU and the EEA to appoint a representative if this is necessary. For example, if you are an applicant from the UK and you also have a representative from the UK, then after, as of next year, you would have to appoint another representative if you want to continue proceedings. As you will realize, if we have so many registered IP rights, it is not possible to notify each applicant or each representative individually. So it was decided that no individual notifications will be sent. Unless there are pending procedures, then the parties will be notified. But if it's a registered IP right, then there are no notifications. Yeah, and then we have, of course, the subject of the representatives of the UK. What will happen with them? They will lose the capacity to act before the EUIPO after the transition period. The first thing that will happen is that they will be automatically removed from all files in EUIPM and RCD proceedings. And it is automatically. The second what will happen is that they will be deleted from the EUIPO database of representatives. And if they are also on the list of professional representatives, they will also be deleted from there. And the third thing is that they will not be able anymore to send any correspondence in relation to a file through their use area. The user area is a certain area on our website where people use. This is the interface for the users. So they will not be able anymore to communicate through this area. And like I've said before, there is one exception, and the exception is if there are ongoing proceedings. What will happen is if there is a representative from the UK and the proceeding is not finished, the representative is allowed to finish the proceedings, and after all proceedings are finished, then they will be declared invalid. Right, so in principle, this should give enough time to people to finish what they were doing. How can you file in the EUIP, for the EUIPO? We allow online filing. This is the so-called e-filing. We still allow filing on paper. On paper is by post, of course. What happens is that the post arrives and all the form and all the images are scanned in our mailroom, and then they will be treated. as a normal application. Of course, you have to take into account that the quality of the images after scanning is a little bit less than if you do e-filing. But in some cases, like I've said before, the shoe manufacturer with the 500 shoes, he finds it easier to just print it and send it by post, and then takes every color difference that they might have for granted. The last option is fax. We are in the middle of deleting the fax option as of next year. For now, it is still possible. What happens is that they can file a fax to a shorter filing date, but the fax has to be followed by the postal sending, and the post, of course, has to be the exact same application as the one that was faxed. Email is not allowed for application. Right. And how much does a design application in the EUIPO cost? For the first design, it is a total of 350, and it's calculated like this. A registration fee, 230 euros, the publications. From design 11 on, it is again cheaper. Then it is 50 euros registration fee, 30 euros publication fee. You see the last column, it says deferment of publication. You see the fees are 40, 20, and 10. And I will tell you afterwards now what it means. The request for deferment means that you can register a design without images being visible, without the design being visible. But it will give you the filing date for the registration. As you will understand, if you want to keep novelty of your design, or if you want to prevent manufacturers or competitors from copying your design, this is a safe option. This has a little fee, like you've seen in the last slide, but it is a safe option. And how does it work? The period for the deferment is 30 months from the date of filing or from the date of priority in the application. The request for deferment must be submitted together with the application, so we do not allow a request for deferment when the design is already filed. It has to be immediately at the same time. There's the deferment fee, like I said already. But one of the characteristics of the deferment is that applicants are able to pay the publication fee at a later stage, at the moment when they decide to publish. This is very interesting, of course, because in this way, you can, if after a certain period, within the period, you change your mind or applicants change their minds and they say, no, I'm not really interested in this design anymore, I don't want to publish, then they save the publication fee for the design. The next characteristic for the deferment period is this. Within the 30 months, you have to submit, or applicants have to submit a publication request. This means that the EUIPO does not automatically publish if there is no publication request or if the publication fee is not paid. In principle, we do not send reminders, but on month 27 of the period, a letter goes out to the right holders of the registered design with deferment to say, okay, you are now in the last 3 months of your deferment period. We still allow you to pay the publication fee, but there's a certain surcharge of 25% if you want to do it. So it is basically, it is a reminder, but with a surcharge. But if the deferment fee of 30 months expires, there is no way back. It is really on the last day of the 30 months The next day, it is not possible to request publication or pay the publication fee. Simply, what it means is that if the deferment period is over, then the design is taken out of a register and it does not have the rights that as a registered design would have. No effects. The next thing in a priority in an application is a priority claim. I'm sure you know what a priority claim is. In the EUIPO, we have a certain way of dealing with priority claims. At the examination stage, we only check the formal requirements. This means we check if the previous application was not filed more than 6 months ago. The applicants have the possibility to submit a priority claim within 1 month after filing. So they can say, I want to claim priority, but I'm not sure about the number. I want to have 1 month. This is allowed. What do we check? We check the file number, we check the filing date, and we check the country of the previous application. And what it means, we check the country is we check if we can see where the previous application is filed. We still require a copy of the previous application. This has to be filed within 3 months after the priority claim. If it is not in one of the languages of the office, we need to have it translated. When it is registered, we publish the priority claim as claimed. So not as accepted, but as claimed. Now I hope that the next slide goes. Yes. The EUIPO has also joined the WIPO Digital Access Service. This is called the WIPO DAS. As of the 1st of July 2020, we are in Office of First Filing, meaning that all our registrations are given a WIPO DAS code that are all uploaded to the WIPO DAS system. And as of the 12th of September, which is quite recent, we are also in Office of Second Filing, meaning that if applicants provide the WIPO DAS code in the application, we are able to download all the priority documents, which is of course an advantage for the applicants because they don't have to submit the priority documents anymore. There is only one thing that has to be taken into account, that the WIPO DAS code has to be provided immediately when you file. We are not able to download the priority documents if the code is not there in the application. Right. Then we go to the design application. What to explain, what is that in the EUIPO, what we do and what we do not do. So what are we examining when we have a design application? First, it has to say really that it is a design registration request. Obvious, but it has to say some of this. We have to have information identifying the applicant. It has to be the correct information. There has to be a design which is suitable for representation. We want it to be of a good quality. It has to have a neutral background and it has to be the same design. Later on, I will give you examples of these 3 things. It has to comply with the definition of a design. The tomato you've seen earlier did not comply. And of course, like I said, it has to be conformed with public policy and accepted principles of morality. But equally important as what is examined is what is not examined. In the EUIPO, we do not examine absolute requirements. We do not examine novelty at the examination stage. We do not examine individual character or the visibility of a design when it is used in a product. We do not examine whether a design has only a technical function, or we do not examine whether a design is a design of interconnections. This is in a later stage when there is a possible case of invalidity for a design, where this is all examined. But to make the examination, to make the application process agile, the option was chosen to not examine these things. Also, we do not examine if there are earlier rights that it might be in conflict with your design application. Unauthorized use of a distinctive design. If, for example, if a design is filed with a trademark which is registered on top of it, this is not for us a motive for deficiency. We register, so this is also not examined. These things are all responsibility of the applicants. And we do not examine whether the applicant is entitled to a design. Right? So good quality. This is what I said. We do examine good quality. Of course, we do examine something. This image, for example, I don't know. I don't know how you see it, but I see it a little bit vague. It is a transparent chair. The background is very light. The contours are so. Another example is this, maybe an opposite example. It is very dark, the image. This is maybe a borderline case. It is very dark. The color is maybe not, maybe it gives the impression that the color is blue. This, for us, would be insufficient quality of design. So this is, these are images that we are not registering. This is the image, how we would like the chair to be shown. Clear contours, it is sharp, the lighting is good. So this is a good example. The next. We do not allow extra elements in the images either. This includes words, arrows, numbers, any type of lines that are there that are outside the design. What you see now, of course, it's a table tennis table. There are measurements and there are lines to indicate where they are. There's a net. I understand, of course, that for applicants, this is very practical information. It explains how the design is, what the dimensions are. However, nonetheless, for registration purposes, this is not allowed. It has to be like this. So clean, without the dimensions and any other lines. If applicants want, they can provide a description where the lines, where there's a sort of explanation if they want to have the measurements. And then we have the concept of neutral backgrounds and additional elements. So what does that mean? The background is neutral as long as its design is clearly distinguishable from the background, from the environment. And this is important without the interference of any other object, which could cast doubt on the protection of a design. So any other object. But it does not have to be on a completely empty background or a white background. It can be a color. It has to be that the design stands out clearly from the background and it remains identifiable. I will show you some examples of these. For example, this. You see a nice bicycle. This is somewhere in France, in Paris. The design is the bicycle itself. Right. As you see, there is quite a lot going on in the background. There are people, and there are cars, there are buildings, and we even go as far as that we can say the people have clothing on. Of course, clothing is also a design. So even if the applicant says in the application, I only want the bicycle, this is not an acceptable image for a design registration. There are too many designs in the background. It is not clear. The scope of protection is not clear like this. So how it should be is like this. This is a white background. Like I said, it doesn't have to be white, but this is the clearest way of showing the design that's for which protection is sought. This is a real design application. I've given you the number underneath the images. Then we have the next topic, which are disclaimers and claimers. The first disclaimer are broken lines. So disclaimers, of course, are to indicate for which part of the design protection is not sought. In this case, this is a jet ski, a water scooter. The applicant only wants the top of the scooter, and then therefore has disclaimed the bottom part and also the steering wheel of the jet ski. Important to know or to is that the disclaimer has to be exactly the same in each of the images. So this is a good example. I don't know if you've seen it this quick, but it is exactly the same. The same parts are disclaimed in all images. This is one type of disclaimer. The next type of disclaimer is shading. The shading, like in the broken lines, has to be the same in all the images as well. Here, the applicant only wants to protect the front part of the car and therefore has disclaimed the back part, including the wheels. There were more images. I will not show them to you here. Maybe you would say that last, the back of the car, why is it there? But this is the most clear way, because then you know that the part that is registered is not visible from the back. So this is why this image is also important. So this is also a good way of representing a disclaimer. The next one is the opposite. These are called boundaries. These are actually claimers. With boundaries, applicants can indicate the parts of a design for which protection is sought. In this case, it is the bottom of that boot. It is important that the boundaries are as precise as possible, and also, as in the other claimers and disclaimers, that it is identical in all images. In the last image, you see the sole, the boot from the bottom. Of course, there, if it is only the sole, there are no lines, because there it is clear that it is only for the bottom of the boot. This is also a real application. And then we have blurring. This is a tire, of course. Blurring is also a way of disclaiming. The importance, it is important for blurring that it is really, really blurred. Not if that does not have, it cannot be a small difference. It has to be absolutely clear that that parts are disclaimed. If we see a disclaimer blurring where it is not, the difference between the two parts is not that obvious, we will send an objection letter to the applicant asking for correction to blur it further. This is a good example of blurring. And then I will show you some examples of designs that have been registered for us. We have the concept of sets of designs. This is a set of furniture. We also have the concept of exploded views and detail views and alternate positions. All these types of views or designs we allow, but there are certain conditions. For example, this is what you are seeing now. You will see that there are all loose elements. They are more or less floating in space. The cushions are floating. It's on top of one another. This image on its own for us is not enough for registration. Right? because it is not clear how the final design will be. However, in combination with other views, it is actually could be acceptable. And which other views do then have to be filed? I'll show you. For example, like this. Here you see that this is an example of an exploded view. Here you see that if you all the floating pieces, if you put them together, then you will have the image on the right. Right, so it is clearly this is garden furniture. It is clearly garden furniture that you can store in a nice way so that it does not take up that much space. So this is an example of an exploded view combined with another view that is acceptable. Within its registration, there are more views, images. And I'll show you what they are. This is one that belongs to it. Here you see, of course, the final design. This is a set of furniture. Sets are allowed in the IPO for registration. This is the image that you had in the beginning. This is the one that you saw also. And these are other ones that are registered. On the small image on the right, you see that these are detail views. Detail views are also allowed, of course, if people feel that certain details are really important to show, and therefore they do a zoom in of the image. But it has to be combined, of course, with the whole image. This is a design for graphical user interfaces. Computer programs for the EUIPO are not allowed for registration. They are not a design. This is software. Software is not a design. But however, the design also has to be the same. Here you see two images. If you look at them, it is clear that the images are not the same. So how do we treat this? Is this for us the same design? And what we do is we compare certain features of the images, and knowing that it is a graphical user interface and that they change, what we do is then we say, okay, this is the same image. Here it is the same. Here it is the same. So knowing that it is a graphical user interface, this is clearly a computer game, we would allow this type of design being registered. This is clearly one game, one design for us. Right, this is the number. So computer programs itself are not acceptable, but graphical user interfaces, they are acceptable. The next that is maybe interesting to know for us is that we have also designs that are called get-up. Get-ups, the name is maybe a little bit strange. They are arrangements of interiors. They can be arrangement of shops, of rooms, of boats, of cars. But it is important to know that it is really the arrangement of the interior that is protected. So it is not everything that you see in the image. It is not the furniture. It is not the logo. It is not, I don't know, the facade of the building. It is the arrangement, the way it looks. So now, how do we treat this? How do we examine these? These two images, okay, they seem to be the same shop. However, for example, in the second image, you do not see the front. So the question is, do we still allow this as one design? And actually, the answer, I did not do the green tick. The answer is yes. Because if you look at it, the furniture is actually in the same place, the same as the graphical user interface. There are enough similarities between the images. You see here, the makeup is there. This is here. there are enough similarities between the images so that it qualifies as one design. This is also an interesting example of GetUp, arrangement of an interior, also real design. This was one image, very nice. It looks like a game hall or a restaurant. And then we have this. But here, of course, the perspective is really different. Here, it is the same as in the shop. Is this really the same design? This is what we examine. Are there enough similarities? I have here the two images next to one another, so you can have a look at them again. So the way we've examined this one is that we just look at the images and we think, okay, right, those chairs, okay, I see them in both images. The one from the back, they are smaller than the other one. They are big in the second image, but you can see that they are there. And then the roof, you can see, yeah, the roof is clearly also the same. And then if you combine all the coloring and other images, I have not made arrows on everything that was examined. But if you look at images, you will see more and more elements that are the same. So therefore, this also qualifies as the same design. And again, it is the arrangement. It is what you see in the picture, the way it is together, that is registered, and not every design that you see in it as a single protection. So the chair itself is like this, not protected. And how do we file? How do applicants file in the EUIPO? We have a website, of course, that people can use to access a user area. They can file an account. They can create an account. There are two forms in the user area to make it easy for the applicants to file. We have a 4-step form, which is for us called a fast track. And we have an advanced form, which is for us called a regular track. A fast track is for us, I don't know, quite fast, because we can register the design then within 2 working days after filing. There are certain requirements for applications that want to be a fast track application. And but this is a really quick way, an interesting way for applicants if they are really in a hurry. The requirements are, for example, that all the details have to be correct, the applicant details, there has to be a valid representative in the file. If there is a priority claim, the priority documents have to be filed immediately. And yeah, and of course, which is logical, there cannot be any deficiencies in the images. As soon as there are deficiencies, it stops becoming a fast track and it converts into a regular track. A regular track application is also examined quite all right, quite quickly. We do this within 10 working days. And so there are 2 separate forms depending on the applicant which they choose. On our website, during the e-filing, we provide many tips, design filing tips and best practices. They are called How to File an Error-Free Application. It is quite extensive, so I will not show you everything that is there. Some examples that I've used are from there. There is also on YouTube a video for people who are not sure that they can watch before they file the application. This is one still of a video. For example, this chair, clearly there's a red chair and there's a transparent chair. These are different designs for the EUIPO. So this is clearly wrong. The video is a minute, almost 2 minutes, and it will give the applicants many examples of what is right and what is wrong.